Hi there, my name's Anthony Pownall. I'm an Associate Solicitor at Bonallack and Bishop. I work in the Personal Injury Department and I'm here to do a short presentation on accidents at work claims. The first step is to try and ascertain what's actually happened. There'll have been an accident at work and we need to sit down with the client, have a good chat about what's happened, get as much detail and information as possible, and obviously reassure the client, because people in this kind of situation are often worried that they may lose their job or have difficulty with their employer, but legislation can protect them from those sorts of difficulties. The law protects employees in certain circumstances from unfair dismissal, and obviously if your employer starts to get difficult, there is the option of reminding your employer of that legislation. And in addition, most cases the employer has insurance and it's the insurance company which deal with it rather than the actual employer. At the beginning of a claim, you sit down with your solicitor and he will go through the accident circumstances to take as much detail as possible about what has happened. That's very important because the solicitor needs from the outset to work out regulations that apply, various health and safety regulations like manual handling regulations, for example, and the old common law negligence, which is a duty of your employer to protect you from foreseeable risks of harm or injury. After details of the accident have been taken, a letter is then written to the employer. That letter sets out in summary form the circumstances of the accident, brief details of the injuries sustained, and then the employer has 21 days to acknowledge safe receipt, and then another 3 months on top of that to investigate and come back with their views on whether they feel they're responsible for the accident or not. The best way of dealing with it is to come to the solicitor first rather than discuss it. There will be discussions with the employer because any sensible or reasonable employer, when there's an accident, will look into and report on the accident circumstances internally anyway, so that you'd expect to see some discussions between the employee and the employer before the injured person comes to talk to the solicitor. Evidence in support of a claim normally takes the form of witnesses. The solicitor should be provided with names and addresses so that he can go and talk to them. Evidence in respect of losses, so if medication, painkillers for example, you need to keep receipts. Notes of time off work, people who look after you while you're not at work, things like that are required as evidence to support the claim.